Major decision with big implications for how DUI cases are prosecuted in Georgia.
Yep, say you're pulled over for DUI and refuse to take the breathalyzer test. Well, today, Georgia Supreme Court justices decided that that should not be held against you in court, striking down a part of our current state law.
Well, Fox 5's Carrie Charles joins us live tonight with more on this decision. Carrie?
Well, so now you see, to carry out a breath test once cooperation is needed, and that could ultimately cause a person to incriminate him or herself, and that's what justices found to be unconstitutional. This, however, does not apply to something like a blood test. A state Supreme Court ruling changes how DUI cases are prosecuted in Georgia. It's all based on one's willingness to take a breathalyzer test, including at checkpoints like this one.
Well, the one thing about it, most people hurt their case so badly before they ever get to that test by talking too much and trying to take voluntary field tests, which are optional and voluntary. Sometimes their cases are already compromised. William
Head is a criminal defense attorney who knows a thing or two about state DUI laws. He co-authored a trial practice manual.
Well, what the issue was whether or not a person's refusal to take a breath test was protected by the Georgia Constitution.
On Monday, the Georgia Supreme Court struck down part of the state's DUI law that said a driver suspected of DUI failing to take part in a breath test meant that information could be used against that person during trial. Justices ruled that's unconstitutional. While there is interest in prosecuting DUI cases, justices say they can't simply change the state constitution.
We have better technology as far as videotapes go than we've ever had in the history of prosecuting a DUI. There's plenty of evidence that they can achieve through a good investigation of DUIs.
Last April, Greg Willis argued the case of a woman before the state Supreme Court.
So that's why this refusal wasn't just her refusing a test, it was her refusal to waive a constitutional right, which was not to incriminate herself.
The decision, a unanimous one.
I thought it would go this way, and the justices did a great job.